Get to the very latest on Measure 114. That's Oregon's gun reform law that voters narrowly passed last month. It's been a back and forth affair today on 114. Really incredible stuff happening, with separate court rulings saying different things from separate levels of government. I hope you're still with me on that. Let's get down to the brass tacks first. Measure 114 will not be going into effect in any form on Thursday, December 8th. That was the day it was supposed to start. But after everything that happened today, as of this moment, 114 is on hold. Now, for those of you watching this episode online after it's aired, it's possible that things have changed. But here on live TV on December 6th at 6:09 p.m., that's what's going on. So, how did we get here? The day started with good news for advocates of Measure 114. A federal judge ruled against the plaintiffs who argued the measure violates the Second Amendment of the U.S. Constitution. The judge said the high-capacity magazine ban and the closure of the background check loophole could take effect on Thursday. The law also requires a permit to get a gun. The judge allowed that to be delayed by 30 days. That's to let law enforcement agencies get that process up and running. But then, yes, wait, there's more. 3 hours after that federal court ruling, a state judge in eastern Oregon, Harney County, blocked Measure 114 completely from going into effect. Now, this ruling was part of a totally separate case from the federal one. In the state case, the judge granted a temporary restraining order against Measure 114, blocking the law in its entirety until he can hear more arguments. Now, you may be asking, whoa, wait a minute. How can a state judge override what a federal judge did just a few hours before? Excellent question. The answer is the judges were considering two separate things, even though both pertain to Measure 114. In the federal case, the judge was weighing the measure against the U.S. Constitution. In the state case, the judge was looking at whether 114 violated a specific part of the Oregon Constitution. Specifically, Article 1, Section 27 of the state Constitution, which reads, "Right to bear arms, military subordinate to civil power. The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power." And the state judge ruled 114 should be put on hold, keeping things the way they are today, until he can hear more arguments and, frankly, sort the whole mess out. We spoke to a Lewis and Clark professor today, a law professor, who said he's not at all surprised that an Eastern Oregon judge sided with gun advocates.
Since state judges are elected, although they're going to be doing their best, they're necessarily going to be responsive to their constituencies to a certain extent because, you can get voted out of office. And so, one would expect that in the eastern part of the state that the judges would be naturally more receptive to gun right claims.
So what happens next? Well, even the Oregon Attorney General Ellen Rosenblum wrote on Twitter today, "It's been a real busy day for 114. But her office will ask the Oregon Supreme Court to take up the case. That would bump the county level judge out of the process. Now we wait for the state Supreme Court to weigh in. But also we want to take a minute to do something you're not going to get in any other news broadcast anywhere in this market. We want to take a deeper look at the federal judge's ruling, which allowed most of 114 to take effect. Again, 114 is not happening on Thursday, but we think it is interesting to see how the judge ruled to allow it to move forward. We're going to show you some of her quotes from her ruling and opinion. And before we get into this, here's the players in this case. The plaintiffs, you're going to hear that a lot. Those are the people who are trying to stop 114 from taking effect. The defendants are the state who are arguing to keep the measure intact. Okay, the plaintiffs are the ones that have to prove the measure is unconstitutional or harms them. In legal language, the burden is on them to do so. All right, here's what the judge said. Plaintiffs, so those are the folks trying to overturn, have failed to meet their burden, showing that they are entitled to the extraordinary relief they seek. Plaintiffs have failed to demonstrate that they will suffer immediate and irreparable harm if this court does not block Measure 114 from taking effect on December 8th, 2022. Plaintiffs have not produced sufficient evidence at this stage to demonstrate a likelihood of success on the merits of their challenge to Measure 114's restriction on large capacity magazines. Plaintiffs have also failed to demonstrate a likelihood of success on their facial challenge to Measure 114's permitting provisions. Now, I got to tell you, that is some good legalese right there. In layman's terms, the folks wanting to block 114 basically failed to prove any of their points. let's hone in on the large capacity magazine component of the measure. Some law experts actually wondered if that could hold up to a legal challenge, and in the federal case, it did. The folks wanting to overturn 114 argued that the large magazines are important for self-defense. The judge looked at that argument closely and said, baloney. Defendants argue, and this court agrees on this record, that the burden imposed by Measure 114 on the core Second Amendment right to self-defense is minimal. Defendants have offered evidence that in over 700 self-defense incidents, less than 0.5% involved more than 10 shots. Plaintiffs have not refuted these statistics with any evidence that magazines capable of accepting more than 10 rounds of ammunition are necessary for self-defense. And what about this? Some argued if a gun cannot accept a magazine that holds 10 or less rounds, well, you're essentially saying a person could not buy that gun, and then you're violating the Second Amendment. Isn't that right? The judge disagreed. She wrote that the state showed evidence that all firearms that can accept a detachable large capacity magazine can also accept a magazine that holds 10 or fewer rounds and function precisely as intended. She also ruled that any gun with a fixed magazine can be modified to hold 10 or fewer rounds and still function as intended. She also ruled that gun stores are not likely to lose significant business under the new regulations. All right, we'd love to hear your thoughts on all of this as well. We know that many of you have real strong feelings about Measure 114. We'd love them to share. We'd love to have you share them with us. Email us at thestory@kgw.com or call and leave us a voicemail, will you? 503-226-5090.